We discuss it later. Let us finish the content first because I want to give a case study. Okay, misconduct. Okay, misconduct means you do wrongful action which is against company policy. Okay? Misconduct divided into two categories, major and minor. Major means serious. Minor means not serious. Okay? Termination of misconduct governed under Section 14. If you all can remember, termination Section 10 up to Section 15, right? Begun under Employment Act 1955. For misconduct termination is under Section 14. You all still remember, right? Sub 1. Sub 2 is suspension for 2 weeks. Okay. What are the major misconduct? Theft, fraud, physical violence, sexual harassment. Gross means serious. Gross means serious insubordination. Drunkenness, willful breach of safety protocol which endangers others, and also serious conflict of interest, corruption. So those are the major misconduct. Not only these, could be others, it's not even these. Okay? If major misconduct, since this is serious, it's need immediate HR involvement. Okay? For investigation, for suspension, because we need to suspend the staff. Okay, why we need to suspend the staff? Why? Any reason? While ongoing investigation, if the staff is around, what the staff can do? Can disturb the evidences. Okay, so that's the purpose. We will suspend the staff. Okay. For the major misconduct, suspension, pending investigation, domestic inquiry, and potential dismissal. Okay. Next, minor misconduct. Minor misconduct is less serious breach. Example, tardiness, minor misconduct. So if minor misconduct, immediate HR involvement is not necessary. HOD can manage, can do counseling your staff by way of ECR. Okay, employee communication record. We have two types of ECR form. You can check ECR in bracket misconduct in bracket for performance. Okay, you must use for performance form. Okay, then you can counseling or you can give warning after ECR. You can suggest to HR whether you want to issue a warning or no need, or you just monitor the staff. Okay, if the misconduct still repeatedly persists, then we must go through the proper process. Show cause, then domestic inquiry letter, and then we need to take decision based on the panel findings. Now, what is the proper disciplinary process for misconduct? Step 1, immediate fact finding before someone or that person destroyed. Who should do? HODs, not HR, because only you have the access to the staff. Okay? HR cannot access, you can access. Then, quickly suspend. Suspension by HR if necessary only. After that, issue a show cause letter. Why you need to issue show cause letter? You are giving chance to the staff to reply, to explain. Okay? After that, if you are not happy with the explanation provided by the staff, you can call for a domestic inquiry. Domestic inquiry, HR will appoint independent panels, 3 or 5 odd numbers. So the panels will decide based on the facts finding and also employee. Outside is enough. Even the staff also cannot bring outsiders.
So this shift is going to be organized once there's a case.
Yes.
You will not have
Fixed team.
fixed.
No. No. So like how HR will select the panels, for example, if the staff check, so they will appoint one person relevant to them.
Is it common for others covering fixed team because looking for office
Fixed team, I'm not sure, maybe some people are trained. They are training how to handle domestic inquiry. Maybe some people are trained or by experience. No, not compulsory. Common practice, I'm not sure. Because every time same team means it would be biased or
fixed and then this sort of case happens, right? And these 4 people
for here we have for appeal we have the committee members, but okay, after the DI over, for the appeal we have a committee. But in that committee we not name a fixed person. From the subsidiary, one representative. So not a fixed person. Another one I want to add, for example, the wrongdoer is the manager. The panel must be above the manager level. Cannot be executive, cannot be the panel. because we have to give a chance for the employee to explain why this thing happened. So if the explanation is satisfied, then we can give whatever punishment management decide. Not happy with the explanation, then proceed with the I.
Any guidelines to points for
We have under our employees.
this is all the girls
Yeah, process is different. We have policy for that. Okay. All these processes are, see right now, employee complain about unfair dismissal. First thing in the reconciliation meeting, the officer will ask whether we have gone through all this process now. That's the first question they will ask. The answer no means then we will be in the trouble. We must go through this process for the misconduct. That's the fundamental question they will ask. This is for misconduct. So, any complaint about misconduct? First, gather all the documents. Next, suspend if necessary. Then, HR will issue show cause letter. You must clearly specify what are the allegations against the staff, so that the staff know why HR show cause them. Okay? Conduct domestic inquiry after the reply. For example, if the staff refuse to reply, how? If the staff refuse to reply within the provided deadline.
Consider failure.
Huh?
Consider that no response, meaning the person is not responsible enough. So can carry on with the next time.
We can carry on with the domestic inquiry. Maybe the staff want to explain in front of parents. We can still proceed with DI. If the staff didn't turn up for DI to defend himself, what we can do? We can give one chance. For example, the date and time fixed at 10 o'clock. We wait until 10. Sharp 10, call the staff. Call one time, two time, three time, no answer, no feedback, nothing. Reschedule to another day. Again, didn't turn up. We can do ex parte domestic inquiry based on facts and findings. Ex parte means without the staff presence. Because we have all the evidences, right? We can produce to the panel, panels can decide. Even court also doing the same. Court also doing the same. Can give ex parte judgment. Okay, now, poor performance. So you need to know differences between misconduct and poor performance. Misconduct means conduct means what? Action, right? So you did something which is against somebody. Okay? Simple as that. Poor performance. Performance means not the dance performance. management can do. Police report and the termination is two different. Poor performance. Poor performance is also covered under section 14, but it's not specifically mentioned about poor performance. But about the misconduct, yes, it's mentioned in the section 14. So poor performance means staff poor quality of work. They inability to meet KPI or frequent errors. If staff doing that, this is not a misconduct, it's poor performance. How to handle it? You need to clearly communicate what is the expectation, how to improve. Must give fair chance to improve. We need to follow fair and reasonable procedure, which is performance improvement plan. Okay? Domestic inquiry not required. How to improve, or if you decided to dismiss this staff, then the process you need to start from performance improvement plan. So you must come up with a document. List out what are the topics they need to improve with the time limit. If they fail to improve, then you must give them warning letters. You can do that minimum 3 months, right? Minimum 3 months.
Minimum,
6 or 3.
well, it really depends on the hiring manager. So sometimes, because for implementation, sometimes it's the semester. Yeah. Sometimes they want to evaluate for the entire semester, for the targets to be achieved. Yeah.
We have guidelines for that, right? We have policy and guidelines. If you want to do PIP with your staff, we have PIP guidelines and policy. Okay, this one for poor performance staff. See, what are the action? You must clear performance expectation. You must talk to your staff. What is your expectation? You means HOD, not HR, because only HOD know what you are expecting from your staff. Then you must set clear, achievable goal. After that, you must put them under PIP, usually 1 to 3 months. Then regularly you must review and give feedback to them. You cannot leave them alone. You must regularly motivate, give feedback, and then you must help them how to improve. Suddenly you cannot give them a new task, make them difficult to perform. After 3 months, bye-bye. You cannot do that. Make sure you must give them daily routine, so that they can show, they can improve, they can perform. If you suddenly give new tasks, definitely they cannot perform, and it's unfair for them. Okay, it's unfair for them. And if you dismiss based on that, it's unfair.
Let's say we find that the staff is maybe not performing a certain skill or area, so we give the new task, we give a chance to the staff to show performance in the different area, and consider performance.
You must properly guide, properly give training.
They can,
Can. And you must give a reasonable time, because that's probably new, right? Okay. So if no improvement, then you must issue warning letter. Okay. Then terminate if necessary. With all documents, then we can terminate them. If they feel we cannot stop anyone from going to industrial court, they still will go. At least
basically to protect you as leaders. In a sense, because yes, it happened before also that I have a cleaner. The cleaner go to Jinjai, and I decided to not to renew the contract, and somehow someone appealed for her, go directly to the cleaner. And the cleaner asked Mr. Siki asked me, I happen to have the recording of this cleaner shouting in the WhatsApp voice. And so that is the evidence. So if I get it correctly, and because also last time Encik Bakar conducted a training on constructive dismissal in Rotary Level 5, I get it that the idea is you see what happened. Human problems will always happen, right? And so it is up to us to manage it. And so what I just want to clarify, if let's say I have staff, dia MC 2 hari, Senin, Selasa, then Rabu Kamis dia tak masuk, and according to handbook, if let's say a staff didn't go to work, didn't inform anyone, it is already a piece of contract. So in this case, HOD can inform HR. So to not so much basically to what do you call it, to blame HR, but it is to build a record, to have evidence build up, correct or not? So then after, if let's say still the day 3, day 4 there is no show up, then we can decide what is the best actions to take. Am I right?
Yeah, like, okay, the last scenario, right, you asked me, MC. So 2 days didn't show up, what you can do, you must attempt to call. Our side, we also must attempt to reach them. So still not success, then we need to issue a more letter first. We must still need to hold the process, because when the lodge of complaint, the industrial department, they will ask for the documents. Yeah. So after the involved letter still didn't show up, then we need to issue a breach of contract with new payment. Yeah. Okay. Constructive dismissal is different. Later I will show you. Okay, this is the process of PIP. So any staff, if you want to put under PIP, you must set clear performance. You must set your goal first. Okay? So that you can monitor and review the staff performance. Then develop, after you set your goal, develop your PIP. You already have template. HR already have template. So you just need to fill up. And provide regular review, feedback. Everything must be documented. And issue warning letters if no improvement, then only you terminate. Okay? No need to go through the mistake.
How long is this PIP?
So,
3 months.
3 months. And when you say regular, we need a feedback how regular is regular.
Or the one is you can set. Okay, if you assign a job, only you know within the duration, maybe 1 or 2 weeks or a month, they can accomplish. So the one you need to set.
then Richard, we have a PIP plan, so it's from 1 to 3 months. So it's up to you, especially for admin role, whether you want to review after 1 month or 2 months or even 3 months. We have given a guideline. Yeah, and the different phases, so at 3 phases. So basically we give like 3 chances. Yeah, but depending on the severity as well. So as long as it's very much documented, let's say the second time it's like really, well, that person is not cooperative and just, insubordination with all these other elements, we may opt to terminate maybe, yeah. But in our performance improvement
already learned earlier, like unfair treatment or favoritism, workplace bullying or harassment, unsafe working condition. So those are the examples about the grievances. So misconduct, poor performance, grievances. So are you clear the differences? Okay, how to handle grievances? HR, first HOD, any grievance staff definitely will go to HOD. Unless they have a problem, direct problem with HOD, then they will go to HR. See, the employer should implement clear guidelines. We have grievances guidelines as well. See, the employees are first encouraged, discuss with HOD. Maybe you are not happy with your salary and your workload. Then you can discuss with your HOD. If not success, then you can bring to HR. See, then usually HR tries to mediate. That's how we will handle grievances. See, first, by before mediation, definitely will investigate. Okay, for the facts. And then communicate with the employee of the outcome. If the employee is still not happy, they can appeal. For the misconduct or performance, for the misconduct dismissal letter, always come with appeal, because we must give the staff chance to appeal. That's one of the requirements the officers will ask. Same goes to poor performance. In the termination letter, there must be a room for appeal. Sometimes the staff don't appeal, straight away they will complain to the industrial department. So it will be one of our points why they didn't appeal. Okay? Grievances also, staff can appeal if the decision is not favourable to them. So, misconduct, poor performance and grievances. Actually, I have prepared activities, so later you can do differentiate between these three: misconduct, grievance, and poor performance. Okay. I move on. Okay. This is very important. Understanding dismissal, termination, and contract ending. Those are types of contracts. Termination of contract is allowable under Section 12, 13, and 15. Section 12 by giving notice period. Section 13 willful breach. Section 15 deemed to end the contract. 2 days the staff disappears. Under the termination of contract, either party can end the contract. Section 12 giving notice. 1 month notice means 1 month notice. 13 willfully breach. Okay, no need to give notice. Willful breach. 15 deemed to breach. 2 days didn't turn up to work, or employer part didn't pay wages. Dismissal, Section 14. Okay. Misconduct or poor performance. Probationary dismissal. Retirement. These are the types of termination or dismissal or end of contract. Retrenchment or redundancy. you all know, right? Like your boss or HOD forced you to resign. Constructive dismissal means if your terms of the employment contract breach, root of your employment contract breach. For example, you are earning 9,000, they just slash to 5,000. It's a root, right? Breach of root of the contractor. It's a constructive dismissal. You can resign. Okay? End of fixed term contract. Fixed term contract means you know when is your contract begin and when is your contract end. Okay? So contract ends at the last date of your contract term. Okay. See, these are the types of dismissal or termination. Okay? Now, I'm going to go through one by one. Before that, we need to understand what is unfair dismissal. Unfair dismissal is you dismiss the staff without unjust cause and no excuse. Meaning to say without valid reason. The reason given by the employer to employee to dismiss is not valid. No excuse means never give chance to the employee to explain on the employee side. That's unfair dismissal. Later I will give you a case study. Then you will come across unjust cause and no excuse in the court judgment. Okay? Burden of proof. Now, you file a case unfair dismissal to the industrial department. Your employee, employer terminated you. You file a case. The employer need to prove to the court you did the wrong. It's not your duty to prove. You complain, right? Employer must satisfy the court this person, employee, did a wrong. Burden of proof on the employer. Because employer is the one terminates you, right? Standard of proof means balance of probabilities. Meaning to say, no need to convince the court 100%. 51% you convince the court, good enough. What to convince? The employee did that misconduct. Okay? Balance of probabilities is just a 51%. Actually, why I'm teaching these legal terms, because later when you do activities so that you able to understand when you read the judgment which I'm going to give you. That's for dismissal cases, because there are two types of dismissal. One is ordinary dismissal. Employer dismiss the employee. Second type is constructive dismissal. Employee resign. Why the employee resign? Because the employer breached important terms of the contract / the salary. Because when touch the salary, that's the root of our contract. Fundamental breach. Because of that reason, I resign. That's we call constructive dismissal. Okay? If constructive dismissal happen, burden of proof on the employee. Employee must show the court employer did the mistake, breached the fundamental employment term. So the burden will shift to the employee. Standard of proof, probabilities. Just convince the court 51% enough. Only for the criminal cases beyond reasonable doubt. Means 100%. You must convince the court this person is the murderer. Small doubt, 0.1% doubt, then the court will punish that person. They will acquit that person beyond reasonable doubt. But for civil cases, balance of probabilities. 51% just convince enough. Okay? Okay, now, important part. Understanding dismissal of a probationer. Okay, who is probationer? Who can answer? Probationer. New hire under trial. Probationers are under trial. Okay? Under trial of doing work. Okay? Okay. Probationers are staff under trial. Okay, that's a clear example. Usually the trial period will be 3 months, 6 months. Okay, 1 month cannot because 1 month we cannot assess their capabilities. Okay. Next, is the probationer enjoy same right as a permanent employee? What do you think?
Yes.
Answer is yes. Okay. But only thing the difference is a probationer holds no claim on the force. Meaning they have no right permanently hold the position because they are under trial. But if you consider their rights, they also enjoy as a permanent staff. Okay? When you dismiss them, make sure you have all the documents. You cannot simply terminate them. Because court see probationer same as permanent staff. Their rights. What happens if no action is taken by the employer after the probation period ends? Is another famous scenario. Probation ends. No confirmation or no termination. But the staff continue to work. How? It's so common because we tend to forget, right? How? What the court say? Court say an employee, that's a judge statement. Employee who is neither confirmed or not terminated at the end of his probationary period is deemed to be confirmed and automatically entitled to all the benefits that come along with the confirmation. Okay? That's a law. Case law. Okay? Now, next, burden of proof. Must the employer prove poor performance before dismissal of a probationer? Yes, the same process must go through. Otherwise, unfair dismissal. Okay? The burden of proof is employer. Can the service of a probationer be terminated before the probation period expires? It's another interesting question. be judged on his suitability to employment within a period of 1 month. In that case, probation period is 6 months, but within 1 month, they terminate, dismiss. 6 months duration to assess their capabilities. But the company terminate him within a month, cannot access. So it's not fair. Okay? Another judgment. It appears clear to us that without anything more, an appointment on probation for 6 months give the employer no right to terminate the service of an employee before 6 months has expired, except on the grounds of misconduct or other sufficient reasons. So we must wait for the duration except any misconduct. Case law. Okay? Because we know probation period also another painful period for the HODs. Right? Okay. Is it necessary to give warning on poor performance before dismissing a probationer? Yes. Same process, because the same right as permanent staff. The process must be same. Okay? See, even a trial period, it's a judge statement. A worker should have some warning that if a trial is not proceeding well. They should know, right? Suddenly we cannot dismiss them without they knowing. At least they need to know. There should be some notice, some warning, some opportunity for discussion and explanation concerning any alleged deficiency. Okay?
Maybe for, let's say for lecturers, okay, they have to provide 3 months notice, right? But we are teaching by semester basis, and they are teaching, okay, let's say if they are, they want to resign their resignation letter in the middle of the semester. So do we have the right, let's say they go to the start of next semester, they may not get lecturers or what, is it okay for them to continue teaching until the following end of the semester, or they have the right, they want to leave within the 3 months, and then they can leave. So if they serve the notice according to the contract, there's their rights to leave. They can
If I'm not mistaken, for academic staff in UCSD, I don't know my college, there is a clause that says that the employment can only end coincide with the end of the semester. So if let's say I resign in July, then so July, August, September. No, let's say I resign in August. So August, September, October. So at the end of October, I will have work. Cannot because our semester starts in September, so we can only. That means it's insufficient notice.
So they also have a conflict of, yeah, I'll
Is that-
explain, I'll let you guys see the.
That's what we did. Okay.
Okay, yeah, let me explain that.
In every contract, there's a reason why it's structured that way. Okay, there's an intention, just like the law, there's an intention of why the section is being structured that way. So in our employment contract for the academics, the reason why, so there are circumstances whereby the resignation period goes into the next semester. So this is what the academies are asking, right? So the reason why it's drafted that way is because there are times where the teaching workload is required, the semester goes on, you have students, right? And the person who tendered resignation will still have to fulfill the duty. And we're juggling between the person resigning and having to fill the headcount for the teaching workload. That's the reason, right, for that. However, if the faculty or the department, the faculty, the academic, you are able to juggle with having a new hire comes in to fill in that teaching position, then we can negotiate on an
staff is not agreeable to early termination to coincide with the end of this semester, say, I want you 3 months, so does it mean that automatically cannot be 3 months, it will be 4 or 5 months to coincide with that? Are we saying that?
Contractually, yes.
Okay.
Contractually, yes, because you have to abide to the
So that
terms
means
of
we
the
do not
contract.
allow them to, okay, so that means we can offer them the option of either earlier
Early
or
release.
later, but not exactly the 3 months, because that 3 months coincides in the middle of the semester. So legally, we can offer these two options.
Yeah, so you can, like, it's always about consent, right? So even though, let's say, if the notice period is supposed to be 3 months, for example, but by mutual consent and mutual agreement, and the faculty has found a new hire to come in to coincide, so you can part ways mutually.
Right,
Yeah.
but those are the options.
Yeah, so again, I want to reiterate the intention of why the contract is being drafted that way is to ensure that there is sufficient manpower for the teaching workload. Yeah, because you have your clients, the students, they're still coming to attend your classes. Yeah, and you don't want to burden other lecturers, academics to be taking on like more than the hours required, like overburdening them too much. So yeah, does that answer?
Yes, that answers. But initially, if the page, they agree that the staff can leave end of the working semester, but however, if they find a new replacement earlier, and then they force the staff to leave, then forcing cannot force.
You can't.
So because they already tendered, and then they were supposed to work until the following semester, and suddenly they changed the discussion.
I know what you're saying. Yeah, so rule of thumb has to be mutually agreed. Yeah, and then the dean or the director will have to consider also the workload. You have to make sure that business as usual, right? The main thing is we are all employees. We have to make sure that the operations and all that is not disrupted. Yeah, so that's the main thing. But we also have to struggle on juggle on the operations and make sure that things are all in order. So the overlaps can also enables the handover. Yeah. Okay.
UIS, I have even 1 year, you know. Maybe the last one. I have 1 year last time, VP, the HR had told me 1 year.
1 year what?
Not this fall.
Why do you not like this?
One semester, they also do a semester.
We are still under probationer. For the probationer, if you failure to give warning letter or conduct DI, then we dismiss. We are at fault. For probationer also, we must give a proper warning letter, also proper domestic inquiry before we terminate or dismiss them. Okay. Any question on probationer rights? Next. Constructive dismissal. Okay. Constructive dismissal means, see, if the employer is guilty of conduct which is a breach going to the root of the contract of employment. Root of the contract of employment is salary, notice period, JD, yes, JD. Okay, relocation with bad faith. Okay, bad intention. So we relocate. Suddenly we ask staff who are working in KL relocate to Sarawak. We cannot do that. Okay. So if they do that, then the staff can resign. That resignation we call as a constructive dismissal. So for the constructive dismissal, this by the employer for the fundamental of your contract. The breach must be justified why you are resigning. And you must leave because of that breach, not for other reason. Because you are resigning, right? Constructive dismissal. So it's not for other reason. Yesterday your boss scolded you and resign. No. You must resign due to that breach. And importantly, you cannot think too long. You want to resign, do it immediately. If you take your sweet time to claim constructive dismissal, then deem acceptance. You cannot take your sweet time. You must do it immediately. Okay? Because the court will see the gap. Okay. Now, your employer, you fail to provide fundamental facilities. Hire a staff, fail to provide desktop. Without desktop, how to work? Hire a videographer, no camera. But you force him to take picture. How to take? Cannot, right? Use your phone. If the staff use old type of phone, cannot. So if you deny that, there is a fundamental breach. It's a constructive dismissal. Same goes to unilaterally you vary the contract term. Suddenly you ask your staff to shift to Sarawak without discussing, without getting your staff on site. Unilateral. Later in the judgment you will see this word. Unilateral means what? Employer decide alone without discussing with the staff. Okay? That's considered constructive dismissal. Okay? Later you will see they slash pilot salary from 13,000 to 9,000 unilaterally. Okay? Also very important, fixed term, repeated renewal. Okay? Fixed term. Fixed term means we know, okay, for the fixed duration, 1 year or 2 years. After that, we renew. Because we want that staff, we want to retain. Okay? Now, fixed term for the specific duration. Example, common jobs, project based. After the project over, that's it. We no longer need that staff. Must be genuine fixed term. Or seasonal job or temporary assignment. After the assignment finish, we don't need that staff. Or temporary replacement. Example, staff go for a maternity leave, another staff, new hire, just hire for certain duration. Those are genuine fixed term contract. See, if genuine fixed term contract, then the dismissal is, if you not be called dismiss, after the contract period end, then the contract end because it's a genuine. If continuity of employment, after 2 years, renew. After another 2 years, renew. Renew. So, how the court look at that contract? See, repeatedly renew multiple times indicates that the position is ongoing and permanent in nature. So, when you want to stop, non-renew, you must justify. Same process, poor performance means PIP, misconduct means domestic inquiry. Okay?
That means, David, that means to say if I have a staff that is fixed term, 2 years, I renew another 2 years, so that is considered possible time.
Consider they are permanent staff.
Consider their permanent staff. That means at the end of the 4th year, it means it's either I will have to do another renewal.
If you not renew, you must justify.
So I have
Before not renew, misconduct means you must do the proper due diligence, due inquiry. Poor performance means you must do PIP. You must justify. You cannot simply do the non-renewal because the position is permanent. Okay. Does your question, does failure to extend fixed term contract amount to unfair dismissal? Okay, this is the important question. See, the non-renewal of genuine fixed term. Genuine fixed term contract, for example, temporary project base. After the project finish, the job is no longer there. So what we see whether the job is available or not available. If genuine means if the contract end is not a dismissal. If renewal multiple times, that person contract renewal multiple times, court see them as a permanent employee. If you non-renewal on the 5th year or 4th year, consider unfair dismissal. If you non-renew after 4th year or 5th year, it's an unfair dismissal because repeated renewal for a fixed term contract may signal that the position is not genuinely temporary. That's how the court look at it. Okay?
Sorry, can you repeat?
Okay. It's a fixed term. Fixed term means for 2 years. If genuine means, for example, project base. Okay, you hire a cleaner just to clean or gardener until he grow flowers or he make that area is nicely planted. So that's his project. After that, if the contract ends, okay, fine, because you only hire for him to plant the plants. Example, cleaner. After the end of contract period, you renew the second year. Third year also you renew. Suddenly 4th year you not renew is unfair dismissal because the job is still there, but you are ending contract with that person, so it's unfair for that person. Because the job is, I know, until this people didn't go to industrial court, you are safe. If they go, things, yeah.
How
You
about
want to keep it that way?
how about due to age factor? Like age factors requirement, right?
Requirement is different.
Statutory, that's a law.
And after retirement period, of course, we will hire them.
So there's no unfair dismissal.
No. This one is like an employee working repeatedly renew. I know, not only cleaner, manually.
So,
But when
yeah.
you dismiss, you must make sure you document the last.
The issue of Petronas staff, this again, that's Petronas staff, there are 5,000 staff, not renewing contract.
Not social.
Tak dengar juga.
Petronas staff, reason case.
Yes, 5,000 start, it's not really contract.
Oh, okay.
The government.
Because retrench is it?
It's not the contract, not renew the contract. Under this category.
Yours, you can end the contract by A contract. You must start to do your proposal. But jangan nanti nak. So far okay? So far okay? Okay,
One more thing. If someone is dismissed, let's say before the contract ends, but is given compensation, let's say equivalent to 3 months salary, that is not unfair dismissal, right? Because there is a fulfillment of contract that the person receives compensation.
but the person must adhere to that. Always should be sure. Agree and then they must sign. Okay, forced resignation. Okay, forced resignation means what? Forced resignation is treated as a constructive dismissal. Okay? Forced is like employer forcing the staff to resign. It's a constructive dismissal. Sexual harassment also constructive dismissal. See, you are doing pressure. Okay? Okay, redundancy and retrenchment. Okay, redundancy means closure after COVID. Too many offices, redundancy and retrenchment. Too many. Okay, because of closure of departments. Employer must make sure the person, the individual is not redundant, but the position is redundant because department closed. No longer that position available. It's not that person. So must make sure, explain that clearly. Okay? Okay? Retrenchment means what? If the person redundant, when you know, stopping them, terminate them, we call it as a retrenchment. Redundant person retrenched by the company, but must follow the process. P4. First, alright. Leave for.
The same first out.
Last in, first out. Last in, first out. Must follow this process for the retrenchment. Okay. Redundancy means not the person redundant because of the closure of department. For example, for UCSI, HR department, legal department is closed. Because legal department closed, no job for me. It's not unredundant. Because my job is not available. Make me, the company retrench me. How to retrench? Process. The redundancy must be genuine. Okay? Must consult with employees. They must tell me, okay, Devi, you no longer needed. ChatGPT is replace you, doing better job than you. So then, from you mean? Okay. So then the selection criteria, LIFO principle, court will look at this principle seriously.
Instead of last in, first out, and first in, first out.
What's the first in, right? Right? different. There's the insurance, EIS. 6 months salary, but within 6 months, please find work after that. No. 6 months is no.
It was, maybe a certain partner, if I remember correctly, it's not, I'm not sure if it's a.
Not full.
Yeah.
First month full, second month they reduce gradually. They reduce gradually. Yeah, not full. Okay. Still, we can survive for 6 months. Alright. I think 6 months, 5 months, they reduce 1 month. Okay. And the company also must pay retention benefits. Okay. If below 4,000 or manual labor is a compulsory, earlier we have seen that some application, some benefit, like for us, based on the discussion and based on the contract or agreement. Okay. After COVID, many people are retrenched. Even my 2 sisters are retrenched. Okay. Retirement. Retirement is very common. Okay. 60 years old. If you want to hire a retired person, encourageable to hire under fixed term contract. Recommended. Don't give permanent contract status. Okay. Okay. Very importantly, you need to know can a company deduct statutory contribution? EPF, SOSO, EIS. For the above 60 years old, EPF 4%, 4%. Not like us, 13%. Okay. EPF contribution up to 75 years only. I'm not sure we have above 75 years old stuff. We have that. Yeah. Some professors. Yes. Yeah. Okay. So after 75, we don't need to contribute EPF. So after 60 years is not covered unless you want it. You can opt in. You can opt if you want. They will cover.
But isn't that a compulsory deduction?
Because under there is an act. Retirement age is 60. So after 60 is not obligation to cover. But if you want, you must go and declare. There is a form. You can opt. But after 60, invalidity pension claim you cannot claim. Permanent disability cannot. Okay. This one, no. EIS, we cannot deduct. No insurance coverage. After 60, you retrench. You cannot get your 6 months payment. Okay, because no EIS coverage. Okay. reasonable period. Usually court will assess the factors like duration of illness, whether the person can recover or cannot recover, how it impacts the employer. Court will assess all these possibilities. We cannot simply terminate the person with prolonged illness. What the judge said, the incapacity of illness should not be temporary, must be seriously prolonged before we terminate. Okay, if temporary means we cannot. So that the employee cannot be expected to perform his duty in the foreseeable future. In such circumstances, the employer has the right to terminate. Understand, right? Okay. Second one, the court affirmed that only a very serious sickness might be considered as an event sufficiently fundamental to frustrate the contract. Okay, it must be serious enough. Then you can end the contract. So this is the step by step how to end. First, get medical evidence from the employee. Assess the reason awareness. Consult and communicate. Then issue notice of intention to terminate. So you must explain why. Okay? How it impact the employer. Give opportunity to respond to the staff. Then, after reviewing, then we can end the employment relationship. Okay? Definitely, yeah, we can frustrate the contract. Short detention, we cannot end. Long detention, yes, end. Okay, next, I think it's you need to know this term. Termination simpliciter means what? Section 12, if you all can remember, Section 12, if you all can remember, allow both parties to give notice, right? Employee can give resignation notice, but in return, under Section 12, the employer give 2 months notice without giving any reason. Is wrong. Legally is wrong. Even though there are clause allowable us to do, but if we do, then they name that term as a termination simpliciter. Cannot do that without reason. But under Section 12, okay. Industrial court say cannot do termination simpliciter. See, because it's not acceptable under industrial law. Must have a valid reason. Not only valid reason, must go through the proper process. Misconduct means DI. Show cause, domestic inquiry, all the processes. Performance issue means PIP, chances to improve. Same. Okay? Okay, now compensation. What are the compensation for unfair dismissal? I explained earlier, first option is reinstatement. By now you all know what is reinstatement, eh? Ask them to join again the company. That's a reinstatement. If reinstatement cannot because the relationship really sour. Okay, if reinstatement means then they will pay back wages. If cannot, that option cannot, then compensation in lieu of reinstatement. Okay, usually for the fixed permanent employee 24 months back wages. It's a cap. You can claim 2 years of your monthly salary. 2 years. Probationer 12 months. That's why be careful when you handle probationer, because equal rights as us. And actually, if you have document, then you can bravely you can face the consequences. Everything is document. In add-on to that, 25 years in a service life and 25 months salary. In addition to that, later I'm going to show millions, the award for give a millions. Okay, because of these calculations. Of course, that person's salary is higher. Okay. That's all. Next is case law, activity. Yeah. Break time. After break time, we do case law. Okay, actual case law. I think like whoever accountant will be able to advise you surroundings stuff. At least you all learn something.
Okay. So 3:45.
Oh, okay, what's that?
Don't read it.
3:30. Oh, too long. Okay, so just 10 minutes. 10 minutes. 10 minutes, then we do activity. We can switch this then. Okay. Okay.
Yes ah. Tadi ke? Tadi bukan bola. Because and the